Hey guys, so I thought I would take you through a financial application. I get a lot of questions where you're trying to get your financial settlement, but the other side just aren't engaging with you. They're not returning your text or your letters or anything like that. So I thought what I'll do is a YouTube video explaining the process and how you just have to continue with that process in order to get your financial order. So the first thing you're going to do is write out to your spouse, and you're going to just make it very clear to them that you are looking to get a financial settlement following your divorce. It's really important that we are transparent right from the beginning. You may need to use this letter later on down the track, okay? So whatever you write when you're entering into a financial application or any legal matter really, always do it with the premise that one day it may be before the court. So keep it, as professional as you can and keep it courteous, but let them know that, look, you're looking to get a financial order in place. If they ignore that letter, then the next thing you're going to do is make a mediation referral. You're just going to contact a mediator. That doesn't have to be necessarily in your area, because a lot of them are doing it online now. And you're going to let them know that you're looking to get a financial order, but that your ex simply isn't replying to your letter, won't reply to your text, etc. What the mediator will do is they will reach out to your ex independently of you and invite them to attend mediation. Now, if your ex just ignores the mediator and doesn't reply to them, the mediator will then give you what we call a MIAMS form. That's the form that you need in order to make your court application, okay? It's going to cost you, ballpark £100, because obviously it's the mediator's time. They're going to have a chat with you. They're going to try and reach out to the other side. They're then going to complete a MIAMS form for you. Once you've got your MIAMS form, you then make your court application, all right? So that's step 3. Carry on, even if your ex still hasn't got in touch with you, is still ignoring all your correspondence, you keep going. So you make your court application using the Form A. Now, I've done a YouTube video on how to complete that Form A, so if you need to take a look at that, then obviously go back. But you'll attach the MIAMS form to the court application and you'll submit that to the court. There's a court fee that will apply when you submit that application of £275. So you've made your application to the court. You will then receive paperwork back from the court, and it will have 3 dates on it. The first date is the date that you have to file your Form E, okay? So again, go onto the government website, you can download the Form E and fill it all out yourself. It's a lengthy document of about 26 pages, but they won't all apply to you, all right? So some of them, there's pages there about limited companies and directorships and all sorts. It covers every possibility. So not every page will apply to everybody. Then what you're going to do is file it with the court, all right? And you've got to file it by the first date on that paperwork that the court have sent you. Now, you will just send the Form E into the court, but what you then have to do is exchange it with the other side. Okay, when you exchange it with the other side, you're going to attach all your financial disclosure. So what I mean by that is, if in the Form E you've listed a bank account, you have to attach 12 months worth of statements for that bank account, the most recent 12 months. If in that Form E you talk about credit cards, you've got to attach the 12 months worth of statements for the credit cards, and so on, okay? File it with the Form E. You're then going to write to the other side again and say, the day is here to exchange our Form Es, are you ready? If they don't acknowledge you, and that's the whole purpose of this video, because they are ignoring you, just keep your Form E, okay? Don't exchange with them, because we're meant to exchange on the same day. File it with the court, but don't exchange with the side. The paperwork that comes from the court will give you a second date, and the second date is where you have to file what we call your preliminary documents, and what they are is these 4 documents here: the chronology, the questionnaire, Form G, statement of issues. The chronology, really straightforward. It's just the dates that you were both born. If you had children, the dates they were born, the date of your marriage, the date of separation. If you lived together before marriage, what date did you move in together? The date of obviously your first appointment, which we'll come to in a moment. You may have issued a divorce petition. What date did you issue the divorce petition on, or did the court issue that? If you've received a decree nisi, the date of that. If you've received a decree absolute, date of that. So it's just a simple table, one piece of A4, dates down the side and what happened on the other side. So that's your chronology. You've then got your questionnaire. Now, the questionnaire comes about when you've received the other side's For Me. In this case, if you haven't received their For Me, you're going to be unable to do the questionnaire. But if you have received their For Me, there may be questions in their bank statements, you know, cash withdrawals or cash deposits, that you want to know what were they for, what happened there. If there's something that you know has happened, for example, they've been promoted and maybe they haven't disclosed their pay slips, that could be a question. So it's any questions really that you would like the other side to answer that are all relative to the Form E. You then have to complete your Form G, which is a really basic form. It's one piece of A4. You'll have received it from the court, and it's a question to say, are you going to be ready to go to court on your first appointment? Okay, so that is just really, you'll cross out, I am not ready. So it reads, I am ready, and just send that back. And then your statement of issues. Again, you can't complete your statement of issues if you haven't had the other side's Form E. If you have had the other side's Form E, the statement of issues might be, for example, number one, we can't agree the value of the former matrimonial home, so we might need a valuation. Number two, is this case suitable for a pension share? Number three, you know, is this case suitable for spousal maintenance? Number four, you know, and I'm not saying that these are statements, these are issues in every person's case. But I'm just giving you some examples of what we use. So number four might be, you know, is this case a 50-50 division of equity, or should we depart from equality there? Once you've prepared these 4 documents, you're going to send them into the court. You're also going to exchange them with the other side. Now, on the same day. So again, you reach out to the side to say, right, we've got the preliminary documents ready. On what date now do you want to swap those across? If you haven't had their Form E, then you're not going to be able to do your questionnaire and your statement of issues. So all you're sending to the court is the chronology and the Form G. All right, don't worry about it, because obviously when we get to the first appointment, we can then let the court know what's happening. So you've done all of that. The third date on that paperwork that you've got from the court will be your first appointment. Now, generally, first appointments are taking place remotely, so via CVP, the cloud virtual platform, via Teams sometimes. Very occasionally, it will be by a phone call. Generally, the court do like to see everybody's face, and you will also be able to see the court's face when you sign into that. The first appointment is going to give you the opportunity to say the other side isn't engaging. I've sent my letter, I've done my mediation referral, I've filed my Form E, I've done as much of the preliminary documents as I can, they're simply not responding. What the court's going to want to know is that they have been served with the paperwork you have received back from the court. So with those 3 dates on that we're talking about here, so long as you can satisfy the court that you have served them, so they're fully aware that a financial application is on foot, what they will most likely do is adjourn the first appointment and give another 3 months, call you back in another 3 months, which I know is tedious, but this is what I meant in the TikTok video about it does lengthen the process. You'll then have a first appointment adjourned, which you'll then go back to with the same information. And during that time period, in between the first appointment and the adjourned first appointment, you're going to keep trying, sending a letter to the other side so that you can show the court you are trying to move this forward. Now, I won't take the process any further than that in this video, but at least that gets you started so that you can, get things moving.